I'm Richard Wilmot-Smith. I'm going to introduce the panel and what we intend to do, and the order in which we intend to do it. And we are going to stop at 5 o'clock sharp. I'm also going to occasionally just stop people when the time is up in order to keep everything absolutely on track. First of all, we're going to do, in relation to this panel, we're going to talk first, and Philip's going to start us off, first about arbitration. Then we're going to segue into both arbitration and adjudication. And Hamish is going to do that. Hamish is now Paul. I've not transmuted. I'm not Doctor Who, but and then Sean and Karen and Philip. But we're going to start with start with Philip, then Hamish, and then we're going to segue into adjudication. Now, to introduce the panelists, I'm going to start first with Karen. Karen Gough is in chambers with me at 39 Essex Chambers and practices internationally as counsel. She's also an attorney at law, an arbitrator, adjudicator, and she has been specializing in construction disputes for over 30 years. And I say that to my certain knowledge because I was at 22 Earl Buildings, Lincoln's Inn, which is now Atkin Chambers, when Karen arrived there as a Robert Aikenhead's pupil, I think. She's appeared in many cases in the courts of England. The CV says England and Wales, but I think it's primarily England. And in the Caribbean, she's a chartered arbitrator and an ADR practitioner. Her CV includes the fact that she is currently vice chair of the SCL, but she is also a past president of the Chartered Institute of Arbitrators. Now, Faye is primarily a quantity surveyor, chartered quantity surveyor, and she has over 25 years' experience in the construction industry. Now, she started training as a QS at 18 and worked predominantly with the main contractors. And she completed her Bachelor of Science honours degree in quantity surveying part-time at the University of Westminster and later undertook a postgraduate diploma in law at Middlesex. And she's a fellow of the RICS, an accredited expert witness, and a practicing member of the Academy of Experts. Faye rather reminds me in one respect of my own mother, who was a veterinary surgeon, who wait for the reveal. When she arrived at the farm, and when Kay arrived on site, Faye arrives on site, the farmer would look at my mother, this is in the 1930s, I should hasten to say, and 1940s, and say, "E, where's the vet?" And we're going to come to a theme from which that story comes. Now, Hamish Clark, aka Paul Mansell, is a chartered arbitrator of more than 35 years' experience and is a practicing architect. And he's acted as an expert architect on 29 occasions and has been a member of a team of experts on many, many occasions. He's given evidence and been cross-examined in the ICC in Singapore, the LCIA, Court of Session in Edinburgh, and provided concurrent evidence, hot tubbing, which I'm a great fan of, by the way, in international arbitrations and remote evidence, and in virtual hearing. His appointments has included disputes with values in excess of $250 million and he's provided expert advisory services in the defect and dispute investigations. Now, Sean is well known to you because he has been the convener of this. He is himself founder of UK Adjudications. He's CEO of Global Expert Witnesses, the firm Hanscomb International, and sits as a quantum expert witness and undertakes works as a tribunal, arbitration, adjudication, mediation, and dispute board member. He's listed on the FIDIC President's list as mediator and adjudicator, and is currently serving in both capacities in Asia and the Middle East. And he's worked across the continents of the world in his career, throughout the world in his career. Now, the last one is I'm going to introduce is Philip, and his is going to be the shortest, and the reason is because he's going to be the first I'm going to call upon. He is an adjudicator, arbitrator, and mediator, and has had 40 years' experience in the construction industry, he is suffused with knowledge of what we're about to talk about. And just to remind you about what we're doing, we're starting off with arbitration. We're going to segue through Hamish, arbitration, mediation, and then we're going to talk about adjudication. Philip, thank you so much.
Yes, I think the black and white photograph really denotes extreme old age, but never mind, I'll try to get through this. So I was given the topic of improvements in adjudication and arbitration, and I said, well, look, as regards adjudication, and as people have been saying all day, really adjudication seems to be working pretty well. So, you know, if it ain't bust, then don't try to fix it. And so, as Richard said, let's move on to talk about arbitration. And really, you know, many times today, people have said arbitration is almost a threat. You know, if all other forms of dispute resolution fail, then we'll threaten you with this retrospective, slow, formal procedure that's going to cost a fortune and that we all don't really want. And as Maggie Thatcher said, no, no, no. I mean, arbitration is inherently flexible and it has a huge potential dynamism. And you know, even to this day, you have arbitrations, the look-sniff arbitrations, where an arbitrator picks up a fish or crumbles some corn in his hand and says it's good, and that's the end of the arbitration, and it's final and binding. So we have an immediacy for arbitration, which we seem to have lost sight of. And so my first idea, which I'm throwing out, is adding salt to arbitration and to construction arbitration, is the fast-track proactive arbitrator. And although I do deal with large and very large construction disputes, what I'm really talking about today is, if you like, the run-of-the-mill, normal building and civil engineering disputes. So one idea is to have arbitrators of different disciplines who will commit to attend to disputes within the duration of the works. We've heard about catching problems in the currency of the works and within a very short time frame. And they would resolve disputes on an inquisitorial and investigative basis, so taking the initiative, as they can do under our statutory scheme, the English statutory scheme, in ascertaining the facts and the law. And they would be listed in the contract. There'd be short lists of arbitrators of different disciplines, for example, structural engineers, architects, mechanical engineers, quantity surveyors, etc. And the idea is that Muhammad goes to the mountain, that the arbitrator goes to the mountain of the dispute. The function of these arbitrators would be attendance on the parties whenever they wanted it, hearings virtual and actual, or on site. You know, they would get themselves to site if required, and they would sign up to this. The fast-track frameworks would be well within the adjudication timeframes for practical issues such as building failures, fabric and structure failures. The timescale could be much quicker than arbitration, maybe within a week. And then in dealing with the practical aspects of the build, the arbitrator will be empowered to issue instructions within his award in substitution for instructions already given, and so a corrective opening up, review and revising role during the currency of the project. And then these arbitrators, these named arbitrators, would enter into short-form contracts with the party to the building contract or civil engineering contract or whatever it was, committing to this regime. And then you would have a let-out clause, of course, which says, look, if I really can't do this, and then you would move to somebody else who would be appointed by a nominating body from a panel of people who are prepared to do this relatively urgent work. So the policy would be to have proactive arbitrators on, as I say, normal construction projects in the UK, working as far as possible to resolve disputes during the contract or very quickly at the end if need be. Somebody was saying right at the beginning, you know, what's the problem with arbitration? The answer is the arbitrators, because we haven't got this frame of mind of dealing with things quickly, of, you know, being prepared to sweat and deal with matters urgently. So it's a change of dynamic where the arbitrator goes to the mountain of the dispute and not vice versa. It stops arbitration being retrospective, and it allows a dynamic correction of the contract process as well. Now, people will say, well, you know, we've been hearing all of this. We've heard about dispute boards. This is like a dispute board, or this is like a 100-day arbitration, or this is like an emergency arbitration. So the natural lawyer's instinct is to find a hole and pigeonhole things. But this isn't that. It's not emergency, because the whole message is that for any dispute, however normal or routine you may think it to be, it's urgent to the parties, and that's where the proactive thing comes in. It's not a dispute board, it's a sole arbitrator. And it's not a 100-day arbitration, it could be a 3-day arbitration. So, you know, let's not pigeonhole this and dismiss it. This is something, an approach which can be enshrined consensually in contracts to make them work, to make them fair. So we move away from this idea of you know, retrospective, formal, stayed arbitration proceedings that really people want to avoid. And because we're in the real world, you know, will arbitrators make money out of this? The answer is yes. I mean, this is akin to injunctive proceedings in many ways, and lawyers expect to be paid for injunctive proceedings, so they would be expected to be paid well for this kind of work. You could put teams together of very, very well-remunerated people, and as long as you do it quickly and as long as you deliver the result, that will be fine. The next idea then, which I was talking to Paul, who is now Hamish, about, is we take the word dispute, we take dispute resolution, we take dispute out, and we talk about problem resolution. And Paul and I were actually talking about this in the context of BIM. But this wouldn't necessarily fit into statutory adjudication, statutory arbitration. It may have to be done on a consensual basis. But we move forward and we say, you do not have to have a dispute to come up with a resolution. It's a radical new approach. As I say, it's consensual. The problem resolver will be empowered to decide and declare a practical solution to a problem referred to him without apportioning blame. The parties bear their own costs, they pay the problem resolver equally, and it would be binding, and I would commend to you binding and final with no appeal. It would apply to situations where the parties didn't want to know who's liable. They didn't care who was right and wrong. They needed to solve a problem. So it would apply to methodology, it would apply to buildability, it would apply to engineering performance, it would apply to process engineering and production lines and all kinds of manufacturing, and it could apply to really all technology where somebody just wants a problem solved. They don't care whose fault it is, they just want a problem solved. And it would apply in particular to situations where you want collaboration and cooperation, and that is essential. And that's where I was talking to Paul about BIM and where people are working together in a sort of virtual environment with shared responsibility, and they've got to find a solution to this design issue. And that's where I think problem resolution rather than dispute resolution really kicks in and really earns its crest. So without more, I pass on to Hamish, who is Paul, or Paul, who is Hamish. Thank you.
Thank you. Hamish will talk for about 5 minutes before we go on to the next. Thank you very much, Philip. That's very... Can you hear me at the back? That's very illuminating. Much appreciated.
Thank you, Philip. I'll do my best to stand in for Paul. He's been taken rather poorly in the last 48 hours, but he did give me permission to say this. He's actually having a CT scan today, so we're going to get our very own BIM model of Paul emerging soon that we can all interrogate and get as much information out of it as possible. Perhaps I feel a wee bit of suffering from imposter syndrome. You probably think I should be a young techie that's standing in front of you discussing BIM, but maybe the fact that I'm standing here helps illustrate some of the issues. In that, first time I worked in an architect's office was in the 70s, and the first thing I had to do was to watercolour 8 sets of drawings to be issued to a contractor. So there were like 50 drawings, all watercoloured, all the different colours. And that determined the volume of data that was involved in the job, And since then, the whole industry's progressed. So, since the early 2000s, there's been a rapid acceleration of the digital environment in which we're all working. But I don't know if the dispute industry or the solution industry has accelerated in the same way. And many of the procedures that we follow actually hark back to the watercoloured set of drawings that I was doing in the 70s. And maybe we should be thinking about the actual information that's being generated by the industry and how the dispute industry should be, and how we go through arbitrations and adjudications, how the information that is available can help resolve the problem. So there's three things I'd just like us to consider. Building information modelling, BIM models, as we refer to them. It's now commonplace in the industry, for a design to be a single collaborative digital environment with multiple parties contributing and sharing information in a single virtual environment. Now, I think we're all used to the concept of a 3D model of a building or a facility, or it could be a piece of equipment, a piece of engineering. But actually, the BIM model has far more in it than that. It's got a record of everything that happens, so it tracks all the changes that people make to that single model. It can assess the causation of an issue that's arising. It can analyse an impact very quickly if you start interrogating that model. So, by interrogating a BIM model, we can see when a design change was made, who made it, and what the impact of that change was. So it's not just a graphic representation, it's got far more to do that. So, analysis can check how well different components, such as steelwork and building services, have been introduced into a design, when this occurred, if the clashes between the components are evident, and how these clashes may impact upon progress of the work. So when objects in a model, for instance, a steel beam, are attributed with costs, programming data, we find ourselves with an incredibly powerful tool. So BIM models are far more than just a 3D image of the building. They've actually got masses of embedded information that can be used in a dispute. Something that we're all probably fairly familiar with are common data environments, or CDEs. So that's parties collaborating on a project where they're sharing information in, if you like, a digital filing cabinet that's there recording all the activities on the job. So in a similar way to models, CDEs often hold that vital contemporaneous evidence needed to make or break a dispute. They can easily dispel spurious claims that a party was unaware of a particular document, and download records may demonstrate when a team member received information. So these data repositories are often, if a dispute arises, held as a ransom as well. So in many cases, if one of the parties loses access to the CDE, which typically has been held by one of the other parties, there can be a lengthy disclosure process. And I think the disclosure process related to BIM models is really important, because it's maybe not evident what information is contained in a BIM model. When a model is released to the other side, or one party holds it, what is actually in that model? What has been redacted from that model? What has been removed? So we're all familiar with the metadata, say, in a photographic image, but BIM models have got the same level of data buried in them that can reveal all sorts of activities within a project. So, they're not simply representations of a design, and they're not simply electronic filing cabinets. They contain they're the CT scan of the project in many ways, and some of my colleagues refer it to, the breadcrumbs that enable the parties, the lawyers, the experts, to understand what is going on, So that's it on the evidentiary side of it, but also, in terms of a tool, when it comes to expert evidence, technical expert as I am, we should be looking at other ways to present that evidence. Are we still bound by printing out documents? It's now all digital, but it's very easy to see how you can have a 3D model that's got a program embedded on it, showing how the production of a piece of plant, or a building, or a facility, how that was generated over time, and the impact that, say, a design issue that wasn't properly coordinated, when that occurred in that program, and the flow of actions that came from that. So hopefully, if we can think about these issues, we can get closer to finding out actually what happens on jobs and projects when they go wrong by interrogating these models, get to the solution of the problems rather than looking at them as disputes. And the type of evidence that can be produced using the likes of a BIM model enables the decision makers to make the best possible decision. So, thanks very much.
Thank you, Hamish, very much. I'm changing the format slightly, so they're going to be a little bit surprised. Faye is going to go next with her presentation, and then we're going to move to a discussion of the themes which come from Faye's talk. And you will see shortly the relevance of my reference to the young vet turning up on the farm, and the young quantity surveyor turning up on the site?
So basically the topic that Sean and I were given was what improvements could there be in adjudication? And I know, Philip, you said it's not broken, you don't need to fix it, but we disagree. So we threw this question out to quite a few people and we came up with a number of things that seem to be a repeating theme that people do think needs changing. So the first one is jurisdictional challenges. I'm sure the adjudicators in here are all very well aware that that happens on pretty much every adjudication. It can waste probably a good few pages at the beginning explaining why you haven't resigned, and you will get numerous challenges that are a complete waste of time. We came up with time frame. It's often too tight when you get large disputes that are quite detailed. You might have a final account thrown at you. You get parties who argue and don't want to give more time. So should we give the adjudicator the right to automatically give time without needing permission? We had consideration when setting those time periods when you're asking for this time, you know, when you've got difficult people and they're all arguing over rejoinders and surrejoinders, how much time do we need to give? So that's probably one of the main ones we wanted to talk about. Party costs, you know, is there a chance that the adjudicator should be allowed to deal with that in more detail? Clearer definition of the issues. You know, some of these adjudications, they come in from non-legally minded people. They don't explain their case particularly well. Do we need to work on clearer definition of the issues? This is a favourite one with the experts, name calling. You know, there's quite a lot of name calling of experts. When you spoke about witness evidence earlier, I thought that was quite interesting as well, because obviously we get quite a lot of the submissions in adjudication where a witness will come and, you know, try and basically say that the expert report isn't correct. You know, again, speaking to the factual terms, they shouldn't really be commenting on that. The pool of adjudicators is a big one that we've discussed. The panel, getting onto the panel is quite difficult. Sean and I, and Gary knows as well, we've had a bit of a discussion about this recently. You know, we've got, I just have to ask the question, who in here is an adjudicator and can you stand up? So I can see 3 women, which, oh no, 4. Okay, so out of this realm of people, that's quite poor. So diversity, have a seat again, you know, or the lack of, is quite a serious issue. And it's not going to change unless we all work to change it. And decisions, should we ask for more reasons from adjudicators? So basically, they're the topics that we've come up with, and we thought what we'd do now is basically have a little bit of a discussion as a panel, and you can throw some questions at us as well.
The last point relates to the farmyard, and that relates to diversity. In the 1930s, my mother was the first female vet to basically go on farms. The generation of Karen and Faye, they are the pioneers of adjudication, females in adjudication. It's not just gender, it's colour, it's age, it's all sorts of things. Could perhaps first Faye and then Karen, could you kick something off before we ask Sean to say something about it?
About diversity?
Yeah, in adjudication.
Right.
Or lack thereof.
Or lack thereof. I mean, I'm looking at Kim's sitting down here.
Exactly.
I don't actually think that there is a bar to women in adjudication. I think there are lots of bars, not just specific to women, to people getting onto adjudication panels and becoming known. And I don't have a recipe as to how that can be achieved easily. You know, you just need to get started somewhere, somehow. There are some panels that you can try and get onto, but basically you need to put yourself out there as somebody that is qualified and able to do adjudication, and cross your fingers that somebody's going to ask for you. Or if you're on a panel and it goes round in a rota, I think Tesco and Tech Bar, they have a rota, they just go through, and your name comes up. So, yeah, there aren't many women adjudicators. I don't think that necessarily that's a problem of the panels and the people that appoint them.
I think you can probably go there, Sean, next, because we've obviously had the discussion.
I disagree. I think a lot of the institutions professional institutions in the country, when they were originally founded, were founded in Victorian times, and they were racist and sexist and classist and elite. Those institutions aren't like that now. But what you do have is a small pool of people that tend to be adjudicators on a lot of the panels, and that's prevented diversity. Some of them state when they're going to open up the panels so people can apply. So they might say, for example, every 2 years our panel will open. UK Adjudicators has been founded 5 years and we're open for people to apply to join the panel. In terms of diversity, we're not happy with the diversity that we've got, but we've tried to be extremely diverse in terms of people's professional backgrounds. We encourage people to apply of any race, gender. At one point, we had an extremely high ratio of female adjudicators initially. Because the pool's grown so rapidly, we've got an extremely low figure. In terms of my understanding of the marketplace in the United Kingdom, I think Tech Bar have the largest amount of female adjudicators. I think there's 12 or 13, my last count. I think 2 or 3 of those are on our panel. When you look at some of the other panels, I don't think there's any women on there at all. So, for example, I believe that the ICME hasn't got a single female on there. I might be wrong, but they don't publish their panels. If you look at Tech Bar, they tell you who's on the panel. UK Adjudicators do that. We published our panel members' photos. And I think unless the panels, the bodies running these panels publicly allow people to see who's on their panels, things aren't going to change. And I think that's extremely important, is the public, the users, want to know who's on the panel.
I think another thing that we spoke about that goes into that is obviously people can ask for specific characteristics and experience, and the problem you've got with the issues we have, we were talking about a certain colleague that we've got, is when you're young and you don't have that experience. It's that old adage, isn't it? You can't get the job without the experience, you can't get the experience without the job, and that is what the problem is with trying to get on some of these panels is. So, you know, Sean's been kind enough to sort of say that he will help with this, but it's whether the other panels will as well. And I know that there's been discussions with the RICS recently, and there is a view that if you are too young and considered to be too inexperienced, it's going to be very difficult to get on the panel.
I'm going to mention somebody who sat here, Matt Malloy. Matt Malloy does an extremely lot of work mentoring people and pupilages, and he's helped so many people be able to get onto our panel. And I think that's one way we can increase diversity and opportunity for people. And it's only the work of people like Matt, where he's giving up his time to do this, it's actually making a real change. And I'd encourage anybody who's an adjudicator here to try to mentor, offering pupilages or some training and shadowing opportunities, and then we're going to be able to change the status quo. But unless people are putting themselves out to do this, things aren't going to change as quickly as they need to.